Welcome back to Ramen Legal Contract Deep Dive. Today, we're going a little deeper and looking at dispute resolution clauses in contracts.
Mm.
You know, those parts that determine what happens when disagreements arise.
Yeah, what's interesting is that a lot of people overlook that these clauses aren't just legal jargon.
Right.
They're really more like strategic tools
Yeah.
that can protect your business, save you time and money, and even preserve valuable relationships.
Yeah, I think that's a great point. And I think a lot of people just think that these clauses are all standard.
Right.
But the Ramen Legal Guide actually reveals some really clever ways to customize them to your specific needs.
Hmm.
So I'm definitely curious to learn more about that.
Absolutely. Ramen Legal actually defines these clauses as the part of the contract that outlines exactly how disagreements will be handled.
Okay.
And getting this right from the start is crucial for any startup or business.
So it's not just about avoiding conflict entirely, but having a game plan in
Yeah.
place when things get a little tense or
Precise.
go sideways.
And for startups especially, where resources are so tight
Yeah.
and every relationship matters, a well-crafted dispute resolution clause can really be a game changer.
Yeah.
Imagine pouring your heart and soul into a project only to have it derailed by a messy legal battle.
Oh, totally.
It can be devastating.
And that also makes me think about the emotional toll that these disputes can take on founders.
Oh, absolutely.
It's not just about the bottom line.
Right.
It's about their vision and all the work that they've put in.
Exactly. So these dispute resolution clauses really help mitigate those risks
Okay.
by providing that clarity, streamlining the process, and offering a path toward resolution that can even help preserve relationships.
Okay, so we've kind of established that these clauses are essential, but can you just break down the different methods available?
Sure.
The Ramen Legal Guide mentioned arbitration, mediation, and litigation.
Right. And each method has its own strengths and weaknesses.
Oh, yeah.
Arbitration is like bringing in a wise referee, an impartial expert who hears both sides and then makes a binding decision. And it's often favored for its speed and confidentiality, especially when sensitive information is involved.
So it's like a more private and potentially faster alternative
Yes.
to a full-blown court case.
Yeah.
But what happens if you disagree with the arbitrator's decision?
Well, that's the trade-off with arbitration.
Okay.
The decision is generally final with limited room for appeals, so it's really crucial to choose an arbitrator with expertise in your specific field.
Makes sense.
Eh.
So arbitration is private, relatively quick, but the decision is binding.
Yes.
What about mediation?
Well, mediation is more collaborative.
Oh,
You can picture it as a structured brainstorming session where you and the other party, with the help of a neutral mediator, try to find common ground and craft a solution that works for everyone.
so it's less judge and jury
All right.
and more let's work this out together.
Exactly. Mediation really puts the power back in the hands of the parties involved, allowing for more flexible and creative solutions.
Okay.
However, there is no guarantee of a resolution
Yeah.
because it's not binding.
That's interesting because it seems like there's more potential for a win-win outcome,
Uh-huh.
but also a risk that it could drag on if one party isn't truly committed to finding a solution.
Yeah, you've hit on a key point there. The success of mediation really hinges on the willingness of both parties to compromise
Right.
and engage in good faith.
Okay, so we've got arbitration, which is binding and confidential, and mediation, which is more collaborative but not guaranteed to result in a resolution.
Right.
What about litigation?
Yeah,
I think most people have a general idea of what that entails, but could you give us the quick rundown?
sure. Litigation is that classic courtroom showdown
Yeah.
with the lawyers and judges and potentially a jury. It's the most formal and structured method, and it's governed by rules of evidence and procedure. And litigation can be a really powerful tool for enforcing your rights, especially when you are seeking a legal precedent.
Did I imagine it's also the most expensive and time-consuming option, right?
Absolutely. And it's very public, which can be damaging to your reputation, especially if you're a young startup trying to build trust in the market.
Right.
And even after a court ruling, there's the appeals process, which can drag things out even further.
So it sounds like litigation is a last resort.
Yeah.
And even then, it's important to weigh the potential costs and benefits very carefully.
Exactly. It's essential to choose the right tool for the job.
Right.
And sometimes a less adversarial approach, like arbitration or mediation, might be a more strategic choice.
Okay, so we've got this menu of options.
Yes.
But how do you decide which dispute resolution method is the best fit for your situation?
Well, that's where the Ramen Legal Guide really shines. It provides a roadmap for selecting the best dispute resolution method based on your specific needs.
All right, let's dive into that roadmap. What are some of the key factors to consider?
Well, one of the first things to think about is the nature of the dispute itself.
Or
Is it a complex issue with lots of technical details or something more straightforward?
yeah, I can see how a complex case, like a patent infringement dispute, might be better suited for litigation or arbitration,
Right.
where you have those more formal procedures
Mm-hmm.
for gathering evidence and presenting your case.
Precisely. But if it's a simpler issue,
Yeah.
like a disagreement over payment terms,
Right.
and preserving that relationship is a priority,
Yeah.
then mediation might be a more effective path.
That makes sense.
Yeah.
Ramen Legal also emphasized the importance of considering your desired outcome.
Right.
What do they mean by that?
Well, it's about asking yourself, what are you hoping to achieve?
Okay.
Do you need a fast resolution to keep things moving?
Uh-huh.
Arbitration might be your best bet.
Okay.
Or is establishing a legal precedent important for future cases?
Yeah.
Litigation might be necessary, but it'll likely take longer.
So it's a balancing act between speed, cost, and the desired outcome.
Mm-hmm.
I imagine cost is a major factor, especially for startups
Oh, absolutely.
that may not have a lot of wiggle room in their budget.
Ramen Legal is very upfront about the financial realities
Yeah.
of dispute resolution. Mediation is generally the most cost-effective option.
Okay.
While litigation can be incredibly expensive,
Right.
arbitration falls somewhere in between.
You know, a lot of startups think litigation is their only option when dealing with something like intellectual property theft.
Uh-huh.
But the Ramen Legal Guide highlighted how arbitration can actually be a faster, more cost-effective way to protect your IP,
Yes,
especially if you want to avoid burning bridges with a partner or competitor.
that's a great point.
Yeah.
And let's not forget about confidentiality.
Right.
If privacy is a concern, arbitration and mediation offer far more protection than the very public process of litigation.
Okay, so we've got the nature of the dispute,
Yeah.
desired outcome, cost, and confidentiality.
Yes.
Anything else we should be considering?
Well, Ramen Legal also delves into the strategic structuring of these clauses. It's not just a one-size-fits-all approach.
Yeah.
You can really tailor them to your specific needs.
Yeah. That's interesting. Can you give us an example of how that works in practice?
Sure. Think of it this way. You wouldn't use a hammer to fix a leaky faucet, right?
Right.
You'd choose the right tool for the job.
Yeah.
The same principle applies to dispute resolution clauses.
Okay.
And Ramen Legal breaks it down into three main approaches:
Okay.
sequential, exclusive, and hybrid.
Okay. I'm intrigued. Let's start with sequential clauses. What are those
Well-
all about?
Well, sequential clauses create a...
Okay.
For instance, you might start with mediation to see if you can reach an agreement amicably.
Uh-huh.
If that fails you, then proceed to arbitration.
So you're essentially building in a chance to resolve things peacefully
Right.
before resorting to more formal measures.
Exactly.
That sounds like a good way to preserve relationships,
Mm-hmm.
especially in the startup world where collaboration is key.
Exactly. And it can save you time and money. Now, exclusive clauses are more straightforward.
Okay, let's hear about those.
An exclusive clause means you're committing to one specific method for all disputes that may arise.
Okay.
For example, your contract might state that any and all disagreements will be settled through arbitration, period.
So it eliminates any uncertainty or potential for debate down the line.
Right.
Everyone knows the rules of the game from the outset.
Precisely. And then you have hybrid clauses,
Okay.
which are a bit more creative.
Okay, I'm sensing this is where things get really interesting.
Yeah.
What's the hybrid approach all about?
Well, hybrid clauses allow you to mix and match elements of different methods to create a custom solution that fits your specific needs.
Okay.
For example, you might have a clause that says minor disagreements go to mediation, while more serious issues like intellectual property disputes go straight to arbitration.
So it's about having a more nuanced approach that recognizes that not all disputes are created equal.
Exactly. Hybrid clauses offer a lot of flexibility, which can be particularly valuable for startups operating in dynamic, unpredictable environments.
Right.
They allow you to adapt to different scenarios and address a wide range of potential conflicts.
This is all incredibly helpful, but I think hearing about how these clauses work in the real world would really bring it to life for our listeners.
Absolutely.
Can we delve into some of the case studies from the Ramen Legal Guide?
Absolutely. They have some compelling examples that illustrate the impact of these different dispute resolution methods.
Yeah.
Shall we start with the case of Tech Synergy?
Yes. Let's hear about that one.
So Tech Synergy was this hot new AI startup that partnered with a company called Data Solutions to develop cutting-edge analytics tools.
Okay.
And they included an arbitration clause in their contract,
Okay.
which turned out to be a wise decision.
Okay. Why is that? What happened?
Well, as often happens in these types of collaborations, disagreements arose over intellectual property rights and how the revenue would be split.
Uh-huh.
Tech Synergy felt that Data Solutions wasn't holding up their end of the bargain. Things got tense.
So they had this disagreement, but they had that arbitration clause in place.
Yes.
What do they do?
They were able to quickly bring in a neutral arbitrator who specialized in intellectual property and tech agreements.
That seems like a much better solution than a messy public lawsuit.
Right.
It sounds like they saved themselves a lot of time, money, and negative press.
Exactly. And the arbitrator ultimately ruled in favor of Tech Synergy,
Okay.
clarifying the ownership of the intellectual property and ensuring a fairer revenue split.
So they got a resolution that protected their interests,
Yes.
and they were able to avoid a lot of the drama and expense of going to court.
Exactly.
To continue working with Data Solutions.
They did. The dispute was resolved in a matter of months, much faster than a traditional lawsuit.
Yeah.
And they were able to maintain their business relationship, which was crucial for both companies.
That's a great example of how arbitration can be a win-win solution, even in a complex situation. What about mediation? Does the Ramen Legal Guide have any examples of how that played out in a real-world scenario?
They do. There's a fascinating case study involving Green Retail, a successful online retailer, and their software vendor, Supply Chain Pro.
Okay.
And their contract included a mediation clause,
Okay.
which proved incredibly valuable when they ran into problems.
What kind of problems?
Well, Green Retail started experiencing major glitches with the inventory management software provided by Supply Chain Pro.
Oh,
These were the kinds of glitches that impact sales and lead to unhappy customers.
I bet. That sounds incredibly stressful.
Yeah, tensions were high.
So they had this mediation clause. Did they use it?
They did. They brought in a neutral mediator to facilitate a conversation.
Yeah.
And this is where the power of mediation really shines. It's all about communication and finding creative sessions.
So did they just patch things up and hope for the best?
Well, they went further than that. They actually revised their service level agreement. Supply Chain Pro agreed to provide additional support to Green Retail, and they even worked out a temporary discount on their services while the software issues were being ironed out.
Wow. That's a great example of how mediation can lead to a win-win outcome that strengthens the business relationship. So instead of this dispute driving a wedge between them, it actually forced them to communicate more effectively and address some underlying issues.
Exactly. It highlights the collaborative nature of mediation and its potential to preserve valuable partnerships.
Okay, so we've seen how arbitration and mediation can play out in real-world scenarios, but I'm curious about those situations where litigation might be the best or only option.
Okay.
Does the Ramen Legal Guide offer any insights into that?
They do. There's a compelling case study involving Innovatech, a biotech startup that developed a revolutionary medical device.
Okay.
They signed a licensing agreement with Health Partners, a larger company responsible for distributing the device. Their contract included a litigation clause, meaning they agreed to settle disputes in court.
So they went the traditional route of legal action. What happened?
Right.
Did they end up going to court?
They did. Unfortunately, Health Partners started distributing a very similar device,
Oh, no.
one that Innovatech believed infringed on their patented technology.
That's a big deal.
Yeah.
Their core intellectual property was at stake.
Exactly. It wasn't a minor disagreement. This was a serious threat to their business.
Yeah,
So they decided to file a lawsuit.
that makes sense.
Ah.
But we've already talked about how litigation can be expensive and time-consuming. What happened in this case?
Well, it was a long and arduous process.
Yeah.
Lawyers, expert witnesses, mountains of paperwork, the whole 9 yards.
Oh,
But in the end, the court ruled in favor of Innovatech.
okay.
They issued an injunction to stop Health Partners from distributing the infringing device and awarded Innovatech damages.
Wow.
So they ultimately protected their intellectual property rights.
That's a victory, but it sounds like it came at a price.
It did. The process was incredibly expensive and time-consuming, and their relationship with Health Partners was irreparably damaged.
That highlights the downside of litigation.
Right.
Even when you win, you can lose.
You said it. The key takeaway here is that litigation should really be viewed as a last resort.
Yeah.
And it's crucial to understand the potential consequences,
Right.
both financial and relational,
Yeah.
before heading down that path.
These case studies really bring it all to life. They show how these seemingly dry legal clauses can have a profound impact on the trajectory of a business.
Absolutely. And remember, these are just a few examples. The Ramen Legal Guide has even more case studies and dives into other types of disputes and resolution methods.
This has been incredibly helpful. We've talked about different types of dispute resolution clauses, the factors to consider when choosing a method, and we've even seen how these clauses play out in real-world scenarios. What else does the Ramen Legal Guide cover that our listeners should know about?
The Ramen Legal Guide also delves into termination clauses, and those are absolutely critical to understand.
Okay, let's talk about those. Why are termination clauses so important?
Right.
And how do they fit into this whole dispute resolution puzzle?
Well, think of termination clauses as your exit strategy.
Okay.
Imagine you're on a road trip.
Okay.
You've planned your route, you've packed your bags, but what if you need to change course?
Right.
Or even turn back?
Yeah.
Termination clauses provide a clear path for ending a contract if needed.
So it's not just about resolving disputes, but about having a clean break if things really go south.
Exactly. It's about protecting yourself and your business in those just-in-case scenarios.
Yeah.
A well-drafted termination clause can prevent headaches, disputes, and even legal battles down the road.
That makes a lot of sense, especially for startups
Right.
that are often operating in rapidly changing environments.
Mm-hmm.
Having that flexibility to pivot or even walk away from a deal can be crucial.
Precisely. And the Ramen Legal Guide emphasizes that these clauses should be crystal clear, leaving no room for misinterpretation.
So you want to avoid any ambiguity that could lead to even more disputes down the line.
Right. You need to clearly define the conditions under which the contract can be terminated, who can initiate the termination, and what the process entails.
It sounds like a lot of the same principles we discussed earlier about choosing the right dispute resolution method also apply here. You need to think strategically and tailor the clauses to your specific needs and the potential risks involved.
Absolutely. And just like with dispute resolution clauses, Ramen Legal suggests considering sequential, exclusive, and hybrid approaches for termination clauses as well.
So you could have a clause that says, if we can't resolve this particular issue through mediation, then either party has the right to terminate the contract.
Exactly. It gives you options and a clear pathway for ending the agreement if necessary.
This is all really valuable